Hi everyone, welcome to our channels. My name is Bongs. I am the moderator and speaker for today's sessions. And please welcome Kun Oradi or PR. สวัสดีค่ะ PR is an expert on PDPAs and she helps so many clients in various industries on the PDPA related works. And it is the great opportunities to have PR here today. So
yeah, it's also my pleasure and honor to be here too.
Yes, okay. So today we will discuss on the developments of the privacy law in Thailand, especially on the notification requirements. So these requirements is stated in the subordinate laws number 2. So before we go further in details, there are certain parts that we need to discuss today. Actually is the key requirements under subordinate laws.
Yes.
So the first part is about the details, information that we need to inform the data subjects. The second part is the change on the purpose that we previously notified to the data subjects. And the last part is the exemptions on the notification requirements. Let's begin with the first part then.
Of course.
So the first part is about the details of notification which the data controller needs to notify to the data subjects. So the notification requirements actually is the key obligations of a data controller, right, PR?
Yes, exactly.
Yes, and there are certain information that's stated in section 23 of the PDPA. So these obligations of the data controller is to comply with the transparency principles and the right to be informed of the data subjects.
Yes.
So before we talk about the developments on this part, PR, can you please provide us an overview of the notification requirement under section 23?
Yes. Actually, the key concept of Section 23 of PDPA is about the data subject's right to know what the data controller is going to do with their personal data. First, they want to know what are the purposes the data controller gonna do with their personal data.
Right.
The second one is what are the personal data that will be collected and for how long. And especially in the case that the data subject has to provide the personal data to be compliant with the law or contract, the data controller has to inform the impact if the data subject do not provide such personal data. The next one, they have the right to know the people or the agencies that to whom the collected personal data may be disclosed.
Right.
And next one is the details of the data controllers and the contact details. And lastly is the rights of the data subjects under the PDPA.
Thank you for the overview of sections 23 PR. So next we will discuss on the developments on each element of section 23. So I understand that the subordinate provide us the detailed requirements on the factor that we need to take into consideration when we talk about the purpose.
Yes.
So can you elaborate more in details?
Of course. According to the draft subordinate law in relation to the notification requirements, there are several factors that the data controller has to consider before notify such purposes. One is the completeness of the purposes. But how can we know that these are all the purposes that company use for processing the activities?
Okay, I think first the data controller need to identify their processing activity so that they will know what is the purpose on each processing activity that they need to be listed out, right?
And of course, based on our experience too, that we suggest the companies to look into each department and list out the activities that they do with the personal data and identify the purposes of that activities. With this method, the company can ensure that all the purposes will be covered in the privacy notice.
Okay.
And the next one is about the wording. The wording, yes. The wording that the data controller gonna use when notify the purposes it has to be clear and easy to understand and attract the attention of the data subjects. When we talk about how to attract the attention, sometimes it depends on the layout that we are going to do with the privacy notice. When we draft the privacy notice, we may use the question instead of the plain title. For example, what are purposes we are going to process your personal data? And yeah, that will be it. This technique will ensure that the data subject will
Pay attention.
pay more attention.
Right. And the next issue is about the language. This is also the hot topic as well,
Yes.
especially for our foreign clients. So whether or not the privacy policy need to be localized into local language. So what is your suggestion to me all?
Well, actually, the law is silent on this one. The law only says that the language the company has to use has to be easy
Yes.
and will not mislead the understanding of the data subjects. So our experience too, we suggest that looking what the group of your data subjects. If the group of data subjects are foreigners,
Yes.
of course you have to use the
Foreign language.
foreign language or English.
English.
So to make it easier for them to understand. But if the data subjects are all Thai, then you have to have in Thai.
Or bilingual.
Or bilingual, yeah. That's what we do for our clients too.
Okay, thank you, Kat. And next, we will talk about the retention period, right?
Yes.
This is also the hot topic as well. So all the clients or the data controller also have the questions on whether or not how long they're gonna retain the personal data in their possessions. So what is the method or the developments on this kind?
Okay. According to the section 23, yes, the data controller have to specify the period, the retention period in the privacy notice. But the draft subordinate law provides the burden of proof has to be on the data controller to prove that such retention period is necessary for the purposes of the processing activity.
So it would be better if the data controller can explain the reason that why they have to keep the personal data, right?
Yes.
Especially if they can rely on the legal obligations
yes.
or the legal requirements.
That the legal obligation, that will be the concrete reason to like our backup.
Yes.
Why we have to keep this personal data.
Agree, yeah. Okay. So next, we talk about the recipients of personal data. So actually, the laws under Section 23 require the data controller to notify the data subject on the recipients of the personal data, right?
Yes. The subordinate law, and of course, like I mentioned earlier, that actually the data subjects has the right to know that where or what is the where is the destination that their personal data will be will go to. So first, the draft subordinate law provides two scenarios. First is where in the cases that the company cannot clearly specify the recipients, the draft subordinate law provides that at least the data controller has to explain or provide enough details or information of the recipient so the data subject can expect and can expect that where their personal data will go. And the second scenario is in the case that the recipient can be clearly specified. In that case, we suggest you to do so and explain it in the privacy policy.
So which means that there should be a list of the recipient,
yes,
right?
It can be a list. It can be a list and attached to the privacy policy.
Right, okay. So this is all for the part one, right?
Yes.
Okay, so then we move to the next sections.
Okay.
So the next section will be the change on the purpose which previously provided to the data subject, right, PR? So it is very normal that the data controller can change their purpose. However, they need to notify to the data subject again, right?
Yes.
So what is the developments on this issue, PR?
Okay. Actually, this concept based on the section 21 of the PDPA that the data controller have to process the personal data according or in accordance with the purposes that already notified the data subjects. For the subordinate law, it provides that if there is a change of the purposes, the burden of proof will be on the data controller to prove that it already notified such change of the purposes to the data subjects.
Right.
That's the development of the subordinate law on this issue.
Okay, so the procedures and the details of the notifications will be the same
Yes,
at the first time.
Yes, exactly. All the elements when the data controller going to notify the purposes still applies to the notification of these changes.
Yes.
It has to be clear, transparent, easy to understand and access.
Yes. Okay. So the last section is on the exemption of the notification requirements, and it is stated in sections 25 of the PDPA, right, PR?
Yes.
So normally the law prohibits the data controller in collections of the personal data from other source, which means that the law encourage the data controller to collect the personal data directly from the data subjects. Yes, but they still can do it if they meet the criteria that stated in sections 25.
Yes.
So they need to notify and obtain consents, if any, from the data subject, or is fall under the exemption under 24 and 26. And the subordinate laws provide us the developments on the exemptions of the notification requirement, right, PR?
Yes. Actually, section 25 of the PDPA also in paragraph 2 provide the exemptions that the data controller do not have to provide the notification requirements. For example, like the data subjects already know such the details, or there is the obstacle or the notification is impossible.
Right.
So the subordinate law elaborate more on the cases that if there is then situations that deemed the impossible, the notification requirement is impossible, or there is an obstacle that restricting the data controller to notify such requirements, such notification requirements. The subordinate law also provides that once those obstacles are removed or the situations already improved, the data controller still has the obligations to notify the notification requirements to the data subjects. And another one that the draft subordinate law provides that the data controller has to provide a suitable measure to protect the rights, liberty, and the benefits of the data subjects when the notifications requirement are exempted. And and also those measure has to be suitable for any effect that the data subjects may face or occur that may occur when there is an exemptions of the notification requirements.
Okay, Kap. So this is all for today's, and we hope you guys have a better understandings on the developments of the laws, especially on the parts of notification requirements.
And we hope that we're going to see you again in the next clip. Our next clip will be regarding the subordinate law in relation to the sensitive personal data under section 26 of the PDPA, and this is very hot issue
Yes, ครับ
right now, so please stay tuned and see you again. Thank you
สวัสดีครับ
สวัสดีค่ะ